I'm Reuben Sullivan, 42 years old, and I've spent the last 15 years building my career at Meridian Solutions, currently serving as the Director of Client Relations. Over that time, I've managed some of the company's most valuable accounts, overseeing complex projects that generate millions in revenue annually. My role demands a combination of strategic oversight, precise documentation, and a deep understanding of both client needs and the internal systems we use to track their progress. I take pride in maintaining a meticulous client management system, one I designed and refined personally, to ensure every detail is accounted for, every milestone documented, and every risk mitigated. That brings me to March 3rd, the date that changed everything. It was our monthly team meeting, a routine gathering with 32 colleagues present from across the department. These meetings are usually where we discuss progress, challenges, and upcoming targets. I would be presenting updates on active projects, client retention strategies, and system improvements I had implemented over the last 18 months. My client files, stored within a custom-configured CRM system, represented a substantial asset, over 1,200 active client records tied to contracts valued at approximately $4.2 million. On this particular day, however, the tone shifted abruptly. My supervisor, Mark Benson, who had recently been promoted under pressure to reduce departmental costs, interrupted my presentation. In front of the entire team, he dismissed my client management system as clutter. His words were sharp, deliberate, and disarming. Then, in a move that stunned everyone, Mark proceeded to delete the client files I had painstakingly maintained for the last 18 months. Watching the progress bar on the screen as those files vanished one by one was like witnessing years of work erased in seconds. The room went silent. 32 pairs of eyes bore down on me, expecting some form of reaction. Internally, I felt the shock of betrayal, but externally, I maintained a composed demeanor. I simply said, "Understood," with the calmness of someone who refuses to be rattled by impulsive acts. But inside, I was already calculating the implications, both immediate and long-term. This wasn't just a reckless outburst, it bore the hallmarks of a calculated professional betrayal. I recognized that Mark's actions were meant to undermine my position, to create a pretext for justifying cost-cutting measures targeted directly at me. By deleting critical client data, he aimed to portray my management as negligent or inefficient, thereby weakening my standing in the company and paving the way for my replacement with a less expensive employee. Yet, I refused to allow this to define the outcome. My years of experience had taught me the value of strategic patience and the power of documented evidence. Right then and there, I started formulating a systematic response. I thought through the layers of protection I had built into my work: encrypted backups, detailed chronological records, and a comprehensive email trail documenting my interactions with Mark and other stakeholders. I knew that while the files on the main server were gone, my off-site backups were intact. Moreover, my employment contract contained clauses on data ownership and severance protections that could be leveraged. My strategic mindset kicked in immediately. I recalled the technical specifics of our CRM architecture, the dependencies only I managed, and the potential fallout from this deletion, not just for me personally, but for the company's client relationships and regulatory compliance. I assessed the silent witnesses around me, colleagues who had seen Mark's impulsive act, and would later become crucial in corroborating the context of this event. Keeping my emotions in check, I acknowledged the severity of the situation. The deletion wasn't merely an inconvenience, it threatened to disrupt contracts worth millions, jeopardize client trust, and expose the company to compliance risks. Yet, I was in control. I knew the next steps had to be methodical, professional, and grounded in documented fact. This moment wasn't the end of my career at Meridian. It was the beginning of a carefully orchestrated response to safeguard my professional reputation and secure justice within corporate parameters. As the meeting concluded, I quietly began to take stock of the immediate damage and the broader implications. My focus was on gathering evidence, consulting experts, and preparing to engage legal counsel. I remained outwardly calm, as any experienced professional would, while internally mapping out every possible angle for strategic leverage. This wasn't about emotional reaction. It was about disciplined, step-by-step navigation, through a complex professional crisis that Mark Benson had just ignited in front of 32 witnesses. I've been with Meridian Solutions for 12 years, a trajectory marked by steady advancement that took me from an entry-level account manager to my current role as Director of Client Relations. Over that time, I've overseen projects generating approximately $8.5 million in annual revenue. This isn't just a number to me. It reflects the trust clients place in our company and in the systems I've developed to manage their needs efficiently and compliantly. My technical skill set extends beyond traditional client relations. I specialize in CRM system customization, having developed tailored modules that streamline client communications and automate routine data entry, significantly reducing errors and improving team productivity. Another critical aspect of my role is secure data archiving. From the outset, I recognize that client records aren't just files, they're intellectual assets, sensitive and valuable. To protect them, I implemented multiple layers of security, including encrypted backups stored off-site, in compliance with the company's data privacy policies and regulations, such as GDPR and CCPA. These measures have saved Meridian an estimated $150,000 annually by reducing data loss incidents and ensuring rapid recovery when minor system errors occur. I also maintain detailed client notes capturing every interaction, contract amendment, and service milestone. This rigorous documentation has consistently provided audit trails during compliance reviews and client disputes, reinforcing Meridian's reputation for reliability. My approach to client management is methodical. Each file is time-stamped, cross-referenced, and backed up in a way that allows quick retrieval and verification. The system I designed wasn't just about organization, it was a strategic asset that supported revenue retention and growth. I regularly trained junior staff on best practices for client data handling, emphasizing accuracy and confidentiality. My efforts have contributed directly to a client retention rate exceeding 92%, well above the industry average, which translates into sustained revenue streams for Meridian. However, this very dedication and the associated costs made me a target when new management, under pressure to reduce expenses, took charge. The initiatives I championed, once seen as essential investments, were suddenly labeled as clutter and inefficiency, terms that masked a broader cost-cutting agenda. I was fully aware that my salary and the resources allocated to maintaining these detailed systems stood out as areas ripe for budget trimming. Despite this, I maintained a professional stance, confident that the value I brought to Meridian, through both client relationship management and technical expertise, was irreplaceable. I also made it a point to stay ahead of regulatory changes and industry standards, ensuring that our client data management not only met but often exceeded compliance requirements. This foresight minimized legal risks for Meridian and reinforced the company's credibility with high-profile clients. I monitored shifts in data security protocols and updated our systems accordingly, coordinating with IT and legal teams to stay aligned with best practices. It's important to recognize that my work wasn't done in isolation. Over the years, I built strong professional relationships across departments, collaborating with compliance officers, IT specialists, and finance managers to align client service delivery with broader company objectives. My role required a balance of technical acumen, interpersonal communication, and strategic foresight, a combination that positioned me as a key contributor to Meridian's sustained growth. Despite my commitment and results, the corporate landscape began to shift. The appointment of Mark Benson as my new supervisor marked a turning point. His focus on immediate cost reduction clashed with my long-term strategies. I sensed early on that my methods, though effective, might be vulnerable under his scrutiny. Yet I stayed committed to professional excellence, documenting every procedural change and communication to maintain transparency and accountability. My client management system, once a point of pride, became a focal point of contention rather than collaboration. Looking back, the foundations I laid, the encrypted backups, the rigorous documentation, and the compliance adherence, were not only essential for everyday operations, but would soon become critical safeguards. In the face of looming challenges, These elements formed the backbone of my professional defense. They ensured that, even if my employer sought to undermine me, the truth and value of my contributions were preserved in documented form. This professional background and technical toolkit gave me confidence that, regardless of the conflict ahead, I had the resources and expertise to respond strategically. My focus remained on measurable results, systematic organization and legal compliance, qualities that defined my career and would prove essential in navigating the complex situation unfolding within Meridian Solutions. Mark Benson's recent promotion to supervisor came at a critical juncture for Meridian Solutions. The company's leadership was under intense pressure to reduce departmental expenses by 20%, a mandate that trickled down to him with an urgency that shaped his managerial decisions from day one. His mandate was clear: cut costs, streamline operations, and deliver immediate financial results. Unfortunately, this created an environment where long-term value, nuanced professional contributions, and system integrity were often sacrificed in favor of short-term savings. Mark's initial assessment quickly zeroed in on my role and the resources I managed. With an annual salary of $120,000, I was among the highest-paid members of the client relations team. More importantly, the client management system I had developed and controlled, which included encrypted backups, detailed chronological client notes, and compliance protocols, was perceived by Mark as overly complex and expensive to maintain. He labeled these vital safeguards clutter, dismissing their strategic importance and focusing solely on their cost implications. This was a fundamental misjudgment of both the operational value and the legal protections embedded in those systems. Mark's plan, as I came to understand through subsequent communications and corroborated by email correspondence, was to leverage this narrative of excess to justify a reorganization. The intended outcome was to replace my role with a junior analyst, likely earning half my salary, who would operate under a simplified, less costly framework. Such a move would align with his cost-cutting objectives, but disregarded the intricate dependencies and risks associated with dismantling the data management protocols I had painstakingly established. Critically, Mark seemed unaware or perhaps dismissive of the company's data ownership clauses explicitly detailed in my employment contract. These clauses clearly stipulated that client data and all associated intellectual property within the CRM system belonged to Meridian Solutions, but were subject to strict handling and protection requirements. By erasing client files, Mark was not only undermining my position, but also exposing the company to potential breach of contract, regulatory non-compliance, and significant revenue loss. Equally significant was my use of encrypted off-site backups, which were maintained independently of the company's main servers. These backups were designed specifically to safeguard against accidental or malicious deletion, precisely the risk Mark introduced. His disregard for these safeguards suggested either a lack of technical understanding or a willful neglect of protocol. Regardless, this oversight created a critical vulnerability in his scheme. Moreover, Mark underestimated my extensive email trail documenting his instructions and interactions. Over the preceding months, I had meticulously archived emails wherein he explicitly directed house cleaning of the client management system, referencing cost concerns and efficiency targets. These communications, combined with documented meetings and witness accounts, provided clear evidence of premeditated intent. Additionally, the non-disparagement and severance clauses in my contract afforded me protections and leverage that Mark appeared not to have fully considered. His impulsive deletion of files during the team meeting was not a spontaneous act, but rather the culmination of a calculated strategy to create grounds for my removal. However, his failure to fully appreciate the legal and operational frameworks governing data management within Meridian Solutions meant that his actions carried significant risk, both personally and corporately. From my perspective, Mark's approach was short-sighted and reckless. He focused narrowly on budget line items without accounting for the broader implications: disruption of client services, exposure to regulatory scrutiny, and the loss of intellectual property that directly contributed to Meridian's competitive advantage. His plan overlooked the fact that my role involved more than data entry or clerical oversight. I was the architect and guardian of systems integral to client retention and revenue protection. This miscalculation became a crucial inflection point. While Mark viewed the deletion as an expedient means to an end, I recognized it as a breach of fiduciary duty and a professional betrayal requiring a methodical and evidence-based response. Consequently, I began cataloging every detail relevant to this breach. The timing of Mark's promotion under corporate directives, his explicit cost reduction targets, the systemic importance of my data protocols, and the legal protections inherent in my contract. I cross-referenced this with system architecture diagrams showing the unique dependencies I managed, dependencies that no junior analyst could easily replicate or replace without significant operational disruption. In parallel, I identified that Mark's ignorance or disregard of these critical factors created a vulnerability. His unilateral decision to delete files without proper authorization or impact assessment violated internal controls and company policy. It also contravened data privacy laws, given the sensitive nature of client records. Understanding these layers of oversight fortified my strategic approach. I reaffirmed that my extensive documentation, encrypted backups, and legal safeguards were not merely administrative formalities, but essential bulwarks against the kind of sabotage Mark attempted. This clarity shaped my resolve to respond systematically, leveraging all available professional and legal instruments rather than reacting emotionally or precipitously. Ultimately, Mark's move to delete my client files was an ill-conceived gambit, a miscalculated effort to streamline costs that failed to account for the complex interplay of contractual rights, data security, and client relationship management. His underestimation of my preparedness and the robustness of my documentation set the stage for a professional reckoning that I was ready to navigate with calm precision and strategic foresight. After the meeting ended and my colleagues dispersed, I immediately turned my focus to assessing the full scope of the damage Mark's reckless deletion had caused. The files he wiped out weren't just random data. They represented 200 active client records, each tied to ongoing projects, contracts, and critical communications. These records collectively accounted for approximately $4.2 million in revenue currently flowing through Meridian Solutions. The sheer magnitude of this loss was staggering, but more importantly, it was quantifiable and traceable. I began by accessing our CRM's audit logs and backup systems to verify which client files had been affected. The deletion had targeted the core folders within my client management module, folders I had personally organized and encrypted over the past 18 months. As I cross-checked the live database against the last backup snapshots, I confirmed that the missing records spanned multiple service tiers and contract stages, from newly onboarded clients awaiting service initiation to long-term partners mid-project with active deliverables. This was not a minor setback. It was a deliberate strike at the heart of the department's operational continuity. Next, I reviewed the contracts associated with these clients, digitally archived as part of our compliance processes. Summing their values, the total contract worth aligned with my initial estimate, roughly $4.2 million in committed revenue streams at risk. Mark's deletion had effectively erased the documentation that supported these agreements and the client histories that substantiated billing and service obligations. Without these files, Meridian was vulnerable to contract disputes, delayed payments, and potential loss of client trust. Simultaneously, I monitored internal communications and human resources activities. I learned that Mark had already begun onboarding his chosen replacement, a junior analyst unfamiliar with the complexities of these accounts and the CRM system I had designed. Moreover, draft termination papers bearing my name had circulated within HR, not formally served yet, but evidently prepared, presumably to coincide with the narrative Mark intended to craft around performance issues and system inefficiencies. This realization underscored the urgency of my response. The company was moving quickly to marginalize and replace me, banking on the data loss to justify their actions. I returned to my employment contract for a detailed legal review. The document contained multiple clauses relevant to this situation. Specifically, provisions protecting my severance pay contingent on unjust termination, as well as data ownership and intellectual property rights related to the CRM system I developed and maintained. These clauses explicitly stated that Meridian Solutions retained ownership of client data, but mandated proper handling and secure storage under my supervision. Unauthorized deletion or mishandling of these records constituted a breach of company policy and potentially opened the company to regulatory penalties. Armed with this knowledge, I cross-referenced the contract with the system architecture diagrams I had created and maintained. These diagrams detailed the CRM's layered dependencies, encryption protocols, and backup routines, many of which only I fully understood and managed. The deletion not only compromised client data, but also created technical vulnerabilities within the system's integrity, as some linked processes depended on data I had secured. The complexity of this system meant the junior analyst Mark intended to install could not reasonably restore or maintain service continuity without extensive training and oversight, which would inevitably result in operational delays and client dissatisfaction. I then compiled a comprehensive timeline of the events and interactions that led to this moment. Reviewing my email archive, I found multiple correspondences with Mark where he had instructed me to clean house and reduce excessive clutter within the client management system, phrases that now carried a much darker implication. These directives, though seemingly innocuous at first, had escalated into a destructive act that went beyond mere cost-cutting. I catalogued these emails meticulously, pairing them with notes from meetings and witness accounts from colleagues who had observed Mark's increasing impatience and hostility toward my department's work methods. This methodical documentation was critical. It established a pattern of behavior and intent, transforming what might appear as a spontaneous outburst into evidence of premeditated professional sabotage. It also highlighted the clear breaches of internal controls and corporate governance protocols. Mark had acted without consulting IT security or compliance teams and without following the company's data management policies, which mandated multi-level approvals for any file deletions affecting active client accounts. I also considered regulatory implications. Given the sensitive nature of client information, including personally identifiable data, subject to GDPR and CCPA regulations, Mark's unilateral deletion exposed Meridian Solutions to potential data breach investigations. The company could face fines and reputational harm if regulatory bodies determined negligence in protecting client data. These considerations broadened the impact of Mark's actions from an internal personnel conflict into a serious compliance issue, requiring formal response. Finally, I reviewed the human element, the colleagues who had witnessed the deletion and subsequent meeting. Their accounts would be instrumental in corroborating the sequence of events and Mark's demeanor. I reached out discreetly to 3 trusted team members, requesting written statements outlining what they had seen and heard, particularly focusing on Mark's justifications and the atmosphere in the meeting room. Their support would add credibility to my case and reinforce that this was not a matter of disputed facts, but clear professional misconduct. In sum, my assessment revealed a multifaceted crisis: operational disruption, contract risk, technical system degradation, legal exposure, and internal personnel maneuvering, all converging around Mark's impulsive, costly decision. Yet, despite the severity of this breach, I remained composed. Each element of the damage was now documented and understood, forming a solid foundation for the strategic response I was preparing. This was no longer about recovery. It was about establishing a professional and legal framework to protect my position, assert my rights, and hold the responsible parties accountable. The path ahead required careful navigation, combining technical remediation, legal consultation, and discreet engagement with Meridian's leadership and external regulators. As I closed my review for the day, I knew the deleted files represented far more than lost data. They symbolized a professional battlefield where documented evidence and strategic patience would be my most potent tools. After compiling and organizing the initial evidence on my own, I recognized the complexity and stakes of the situation demanded experienced legal counsel. I reached out to Laura Spencer, an employment lawyer whose reputation I had researched extensively. Laura had over 15 years of experience specializing in employment disputes, wrongful termination cases, and corporate data governance issues, precisely the expertise I needed. I briefed her comprehensively on the events, emphasizing the deliberate deletion of critical client files by my supervisor, Mark Benson, and the broader implications this had for both my position and Meridian Solutions' operational integrity. Laura immediately understood the gravity of the breach and its multifaceted nature. We scheduled a series of meetings, both virtual and in person, to begin assembling a comprehensive evidence dossier that would support not only potential litigation, but also strategic negotiations for a revised role within the company. Her approach was methodical and thorough, reinforcing my commitment to a calm, documented response rather than reactive confrontation. Our first step was to gather all technical documentation related to the deleted files. I provided Laura with access to the encrypted off-site backups I maintained, which were stored on secure servers with multi-factor authentication and encryption protocols meeting industry standards. These backups represented redundant data storage that Mark's deletion failed to impact, preserving the integrity of client records and contracts. Laura noted the importance of demonstrating that these backups were not only intact, but also legally recognized by the company's IT policy, which explicitly required secure data redundancy. Next, we focused on contractual documentation. I compiled a detailed collection of my employment contract clauses concerning data ownership, severance terms, and non-disparagement agreements. These clauses were crucial. They explicitly protected my rights as an employee and outlined Meridian's obligations regarding client data management and intellectual property. Laura examined these contracts carefully, identifying specific language that would strengthen our case against wrongful termination and support claims related to the sabotage of company assets. We also curated an extensive archive of email correspondence between Mark and me. These emails revealed a clear pattern: Mark's repeated references to cleaning house, eliminating excess clutter, and his dissatisfaction with the complexity and cost of my client management system. These messages, time-stamped and unaltered, provided a chronological narrative that underscored premeditation rather than impulsive behavior. Laura emphasized that such documented instructions were strong evidence of an orchestrated effort rather than a spontaneous managerial decision. To solidify our position further, I coordinated with 3 trusted colleagues who had witnessed the deletion incident and subsequent departmental reactions. Each provided written statements detailing their observations of Mark's conduct and the meeting's atmosphere. Their accounts corroborated the timing and nature of the deletion, describing it as abrupt, unauthorized, and damaging to ongoing client operations. Laura advised that these witness statements would be instrumental in countering any company claims that the deletion was justified or routine. Additionally, we reviewed client revenue reports tied to the affected files. By quantifying the financial impact, approximately $4.2 million in active contracts, we established a compelling argument regarding the material harm resulting from Mark's actions. Laura noted that framing the case in terms of tangible business losses would resonate strongly in negotiations and potential regulatory reviews. Throughout this phase, Laura and I maintained a strict chain of custody for all evidence. Digital files were secured with cryptographic hashing to prevent tampering, and physical copies were stored in a secure location under controlled access. This attention to procedural rigor was essential to ensure that our dossier would withstand scrutiny in any formal proceedings. Our strategic planning extended beyond documentation. Laura suggested a timeline mapping Mark's escalating hostility, the deletion event, and subsequent company actions. This timeline would serve as a visual and narrative tool to demonstrate the progressive nature of the conflict and Meridian's failure to address early warning signs. I also began drafting a preliminary communication plan to manage internal and external stakeholders, preserving client relations while limiting disclosure of sensitive legal matters. Critically, Laura and I explored leveraging clauses related to non-compete and severance benefits. Instead of pursuing litigation as the first course, we aimed to negotiate a superior role within the company, or if necessary, secure a severance package commensurate with the value I brought and the damages incurred. This approach aligned with my professional philosophy, resolving disputes through measured, contractual leverage rather than adversarial escalation unless absolutely necessary. By the end of these initial weeks, our dossier included the encrypted backups validating data integrity, employment contracts highlighting my legal protections, an email chronology evidencing Mark's intent, witness statements confirming unauthorized conduct, financial analyses quantifying losses, and a procedural timeline framing the broader context. This comprehensive foundation empowered me to proceed with confidence, knowing that my strategic response was built on solid facts and expert legal guidance. Throughout this period, I maintained professional composure, understanding that any misstep or emotional reaction could weaken our position. Instead, I focused on clear communication with Laura, prompt evidence gathering and preparation for the next phase, engaging Meridian's HR and legal departments with an undeniable, meticulously documented case. This deliberate and systematic approach was my best defense against the sabotage and the key to reclaiming my professional standing on terms favorable to me. Laura's analysis of my case was incisive and detailed, revealing multiple layers of legal and professional breaches that I hadn't fully appreciated on my own. From her perspective, Mark's actions constituted a trifecta of serious violations: wrongful termination without legitimate cause, intentional destruction of company intellectual property, and a breach of his fiduciary duties as a supervisor entrusted with protecting the company's interests. First, she emphasized the wrongful termination angle. Mark's deletion of my client files was clearly a pretextual act designed to manufacture justification for my dismissal. There was no documented performance deficiency on my part. In fact, my record and the revenue figures I managed spoke to the opposite. Laura pointed out that under employment law, such manufactured cause for termination was not only unethical but legally indefensible, especially when coupled with prior documented instructions from Mark that indicated premeditation. This set the stage for a strong wrongful termination claim, bolstered by the extensive documentation of the deletion incident and the timeline of events leading up to it. Next, Laura highlighted the destruction of intellectual property within the CRM system. The client data and the custom modules I had developed were company assets protected under intellectual property law and company policy. Mark's unilateral deletion, without following mandated IT protocols or notifying compliance officers, violated these protections. We identified specific clauses in the company's data governance policies that required multi-level approvals for data deletions, none of which Mark obtained. His disregard for these procedures exposed the company to operational risks and potential legal liability. Since those client files were not just data points, they represented contracts, billing histories, and service agreements critical to Meridian's business continuity. Laura also stressed the fiduciary duty breach. As a supervisor, Mark was bound to act in the company's best interests, maintaining trust and safeguarding assets. By deliberately sabotaging client records, he breached this duty. His actions not only compromised the company's operational integrity, but also potentially exposed Meridian to regulatory sanctions, given the sensitive nature of client information governed by laws such as GDPR and CCPA. Laura prepared a detailed memo outlining these breaches for formal submission to Meridian's HR and legal teams, emphasizing the gravity of Mark's misconduct and the consequent corporate risk. In collaboration with IT experts, we verified the technical ramifications of the deletion. Our analysis showed that Mark's actions disrupted interdependent data streams within the CRM system, causing cascading errors that would require substantial recovery efforts. The cost estimates for restoring full functionality, considering labor, data reconstruction, and client outreach, were significant, amounting to tens of thousands of dollars, if not more. These figures added tangible weight to our claims of financial damage and operational disruption. Regulatory compliance issues further complicated the matter. Given that client files contained personally identifiable information and sensitive contract data, the unauthorized deletion constituted a potential breach of data privacy regulations. Laura coordinated with a compliance consultant to document Meridian's exposure to fines and penalties, which could reach six-figure sums depending on regulatory findings. This dimension added external pressure on the company to resolve the matter swiftly and thoroughly. Throughout this process, Laura emphasized the importance of maintaining a robust evidentiary chain. We meticulously catalogued every piece of relevant documentation, encrypted backups proving data retention, email threads revealing Mark's intent, witness statements corroborating the incident, and legal contracts affirming my rights and Meridian's obligations. Digital evidence was secured with cryptographic hashing, ensuring integrity and admissibility in any potential proceedings. Physical copies were stored securely under controlled access, following best practices for document preservation. Laura's legal strategy aimed not only at litigation, but also at leveraging this comprehensive case to negotiate from a position of strength. She advised me to prepare for multifaceted engagement, discussions with Meridian's HR and upper management, regulatory communications, and possibly arbitration or court proceedings if necessary. Her counsel stressed professionalism and patience, underlining that a well-documented systematic approach would maximize pressure while minimizing reputational damage. In parallel, we outlined a communication plan for internal and external stakeholders. Laura recommended carefully limited disclosures to key clients, protecting business relationships without exposing internal conflicts prematurely. At the same time, we prepared to counter any company narratives that might misrepresent my actions or responsibility. The goal was to affirm my professionalism and control of the situation, preserving my standing while the legal process unfolded. By the end of this phase, the dossier Laura and I compiled was both comprehensive and strategically layered. It combined legal contracts, technical analyses, financial impact assessments, witness testimonies, and regulatory risk evaluations. This multidimensional evidence package positioned me not just as a wronged employee, but as a key stakeholder safeguarding the company's assets and compliance. Laura's expertise transformed fragmented facts into an integrated case, primed for negotiation and enforcement. My confidence in our approach grew as Laura and I continued refining the dossier. I maintained strict professional composure, documenting every interaction meticulously and avoiding any impulsive remarks. This disciplined stance preserved my credibility and ensured that every step forward was grounded in strategic foresight. The complexity and seriousness of the breaches uncovered demanded a calm, law-driven response, and that is exactly what Laura and I were building together. After completing our dossier and refining our strategy with Laura, the next critical step was to formally engage Meridian's Human Resources Department. I drafted a carefully worded request for a meeting, emphasizing a professional tone and focusing on the importance of discussing documented concerns related to recent events. My objective was clear: present our comprehensive evidence calmly and professionally to initiate an official dialogue, thereby ensuring the company's leadership was fully aware of the severity and complexity of the situation before it escalated further. In the meeting request, I outlined that the discussion would cover multiple issues, including the unauthorized deletion of client files, potential breaches of company policy, and the implications for ongoing operations and contractual obligations. I avoided inflammatory language, instead framing the matter as a serious operational and legal concern that merited immediate attention. My intent was to demonstrate my commitment to resolving the situation through established corporate channels, underscoring my professionalism and willingness to collaborate on a constructive solution. When the meeting with HR was scheduled, I prepared meticulously. I organized printed copies of all key documents, encrypted backup logs, excerpts from my employment contract highlighting data ownership and severance protections, the detailed timeline of Mark Benson's instructions and actions, and witness statements from colleagues who had observed the deletion incident firsthand. I also prepared digital versions on a secure, password-protected device to facilitate reference during discussions. This preparation ensured I could navigate the conversation with precision and readily supply evidence to support every claim. During the HR meeting, I maintained a composed demeanor, speaking clearly and factually without allowing emotion to dictate my tone. I began by summarizing the sequence of events, referencing the team meeting where Mark deleted critical client files in front of 32 witnesses. I emphasized the operational disruptions this caused, including the loss of records tied to $2 million in ongoing contracts and the associated regulatory risks due to improper handling of sensitive client data. I then presented the relevant contractual clauses that protected my role and outlined the company's obligations. I carefully articulated how Mark's unilateral actions breached internal protocols and fiduciary duties, supported by documented email threads where he directed clean house efforts aimed at undermining my client management system. I introduced the witness statements, corroborating the timeline and intent behind the file deletions. Throughout, I stressed that my approach was to seek a constructive resolution that balanced the company's business needs with respect for contractual and legal obligations. I avoided accusatory language, focusing instead on presenting a clear, evidence-backed narrative. Concurrently with the HR engagement, I filed a formal complaint with the State Employment Commission. The complaint detailed the wrongful termination risks, unauthorized destruction of company assets, and violations of data privacy laws stemming from Mark's actions. I included our comprehensive evidence package, copies of contracts, backup verification, email correspondence, and witness statements to substantiate the claims. This filing was strategic. It introduced an external oversight mechanism that increased pressure on Meridian to address the situation appropriately while protecting my legal rights. In addition to these formal channels, I discreetly alerted several key clients affected by the deletion incident. Without revealing internal disputes or legal details, I informed them of potential service disruptions and reassured them of my personal commitment to restoring full operational continuity. This communication was critical to preserving client trust and goodwill during a period of uncertainty. By proactively managing client expectations, I mitigated the risk of contract terminations or reputational damage that could have compounded the company's difficulties. Throughout this period, every communication I engaged in, whether with HR, legal counsel, clients, or colleagues, was meticulously documented. Emails were archived in dedicated folders, phone calls logged with timestamps and summarized content, and in-person conversations followed up with written confirmations. This level of record-keeping was part of my broader strategy to maintain control over the narrative and ensure that any future negotiations or proceedings would be supported by an unassailable evidentiary foundation. Anticipating resistance from Mark and potentially other leadership figures, I prepared for negotiation by outlining the parameters I would insist upon: reinstatement or transition into a director-level role with clear authority over client data management, improved severance terms tied to performance and non-compete clauses, and formal acknowledgement of the misconduct that precipitated this crisis. I shared these parameters with Laura, who advised on framing them to maximize leverage, while maintaining a tone conducive to settlement rather than adversarial litigation. This dual-track approach, engaging HR internally while involving the Employment Commission externally, placed Meridian under multifaceted scrutiny. It created procedural momentum that made ignoring or minimizing the issue increasingly untenable for the company. Meanwhile, my measured professionalism and strategic patience conveyed that I was prepared to escalate matters if necessary, but preferred a resolution aligned with contractual rights and mutual business interests. The situation remained delicate. While the deletion and its fallout had already generated operational challenges, the formal processes I initiated were only beginning to unfold. Mark's replacement efforts were progressing, and internal uncertainty permeated the department. I maintained a neutral, collaborative front in public and internal forums, careful not to reveal the full scope of our preparations. This restraint was intentional. By controlling information flow, I preserved my professional reputation, avoided unnecessary panic, and kept Meridian's leadership, the ultimate decision-makers, focused on resolving the matter through the channels I had established. In sum, this phase marked a critical turning point. My strategic engagement with human resources and regulatory authorities transformed a covert attempt at professional sabotage into a formally recognized corporate and legal issue. It set the stage for subsequent negotiations and enforcement actions, ensuring that Meridian could no longer disregard the consequences of Mark's reckless deletion. Through disciplined documentation, procedural rigor, and professional communication, I positioned myself not merely as a victim, but as a decisive actor, shaping the course of events with clarity and authority. Following the formal steps Laura and I had initiated, the situation at Meridian quickly escalated in ways that confirmed our strategic analysis. Mark's replacement, the junior analyst hastily brought in to fill my role, lacked the deep technical knowledge and contextual understanding necessary to manage the complex client data system I had developed and overseen for years. Almost immediately, signs of operational strain began appearing across internal platforms and through direct client feedback. Within days, several key client accounts experienced troubling errors, misfiled contracts, delayed billing, and inconsistent service updates. These were not random glitches, but systemic failures traceable to the mismanagement of the CRM data infrastructure. The junior analyst, unfamiliar with the nuanced dependencies and encryption protocols, inadvertently corrupted portions of the client records. IT support tickets surged as the errors multiplied, requiring urgent attention from specialists who recognized the severity of the disruption. The incident logs reflected a clear pattern, handling mistakes that only someone with extensive training and intimate system knowledge could avoid. Simultaneously, whispers of client dissatisfaction began filtering upward. Major accounts, those responsible for a significant portion of Meridian's revenue, lodged formal complaints citing concerns about contract accuracy and service continuity. Some clients questioned the company's operational reliability, requesting reassurances that their sensitive data remained intact and protected. These concerns created immediate business risk. The loss of trust could lead to contract renegotiations, delayed payments, or even outright cancellations, amplifying the financial exposure triggered by Mark's initial deletion. Compounding the internal turmoil, regulatory bodies initiated preliminary inquiries focused on the data deletion incident. Given the sensitive nature of client information and the stringent requirements of data privacy laws, such as GDPR and CCPA, the authorities flagged Meridian for potential non-compliance and data mishandling. These inquiries brought additional scrutiny to Meridian's data governance practices, raising the stakes considerably. The company now faced not only operational disruption, but also the looming possibility of regulatory fines and reputational damage, factors that Mark had apparently not anticipated or fully understood when he deleted those files. Amid this growing pressure, Mark's behavior shifted noticeably. Previously authoritative and dismissive, he began reaching out to me with a markedly different tone. I received several phone calls and emails from him, proposing to smooth things over through consulting arrangements, offering fees to leverage my expertise to help repair the disruptions caused by his decisions. Recognizing these overtures as attempts to mitigate his own liability and regain control, I declined professionally and firmly. I directed all communications to Laura, making clear that any further contact would be handled through legal counsel. This measured refusal reinforced my position and signaled that I was not amenable to informal resolutions that failed to address the underlying breaches. Within the department, colleagues expressed growing concern, though their apprehension was cautious and often private. Some reached out discreetly, offering support or sharing observations about the increasingly chaotic environment. They acknowledged the challenges posed by the new analyst's inexperience and the operational void left by the deletion of critical data. I maintained a neutral, composed front when interacting with the team, neither confirming nor denying the full scope of the internal conflict. This restraint was strategic, to avoid fueling rumors, maintain professional credibility, and prevent any leaks that might undermine the legal process or client confidence. Throughout this period, I continued to document every development with precision. Each new client complaint, internal system error, and regulatory communication was logged and time-stamped. Emails between myself, IT, HR, and other stakeholders were archived in dedicated folders with detailed notes on content and context. Calls and meetings were summarized immediately after occurrence, ensuring a continuous, unbroken record of the evolving crisis. This meticulous record-keeping was critical. It preserved the integrity of evidence that would support negotiations or litigation, and it demonstrated to Meridian's leadership that I was methodical and unflappable despite the mounting pressure. At the same time, I coordinated closely with Laura to update our dossier and refine our strategy. We anticipated Meridian's efforts to contain the fallout and perhaps shift blame, so reinforcing our evidentiary foundation was essential. Laura advised maintaining a posture of professionalism and patience, emphasizing that the accumulating operational failures and regulatory inquiries inherently increased Meridian's incentive to negotiate seriously. Our goal was to leverage this mounting pressure to secure a resolution that recognized my contributions, protected my rights, and restored proper management to the client data systems. Despite the challenges, I remained focused on the broader objective, transforming a situation engineered to marginalize me into an opportunity to redefine my role and secure fair compensation. I avoided reactive communication, refraining from emotional responses or public statements. Instead, I let the facts speak through the documented failures of the replacement and the escalating regulatory scrutiny. This approach preserved my professional stature and enhanced my credibility with Meridian's HR team, external regulators, and key clients who valued stability and accountability. The professional environment at Meridian in those weeks was tense and uncertain. Mark's replacement struggled visibly with the workload and technical nuances, while leadership wrestled with the emerging crisis. Meanwhile, I continued preparing for upcoming negotiation phases, confident that the combination of operational failures and regulatory pressure would compel Meridian to reconsider its stance. The unfolding consequences of the file deletion served as a living case study in the costs of undermining experienced professionals and disregarding established data governance protocols. In summary, the immediate aftermath of the deletion exposed critical vulnerabilities in Meridian's client management operations. The junior analyst's mishandling triggered a cascade of client complaints, internal system failures, and regulatory alarms. Mark's attempts at informal damage control were professionally declined, reinforcing the gravity of the situation. Meanwhile, my methodical documentation and controlled communication preserved both my reputation and strategic leverage as the company grappled with the tangible fallout of his impulsive actions. The stakes were rising, and the path ahead demanded continued discipline and calculated engagement. As the situation intensified, Laura took decisive legal action. She filed a formal wrongful termination claim on my behalf, meticulously detailing the sequence of events that led to the sabotage of my position. The claim highlighted key points: the absence of any legitimate performance deficiencies on my part, the deliberate deletion of essential client files by Mark Benson, and the clear pretext this provided for wrongful dismissal. This document was structured to emphasize the calculated nature of Mark's actions, supported by the comprehensive evidence we had gathered, encrypted backups, contractual protections, email communications, and witness statements. Simultaneously, Laura dispatched an official notification to Meridian Solutions compliance officer. This was a critical step designed to trigger an internal investigation into the unauthorized deletion of client data, which constituted a breach of multiple company policies and potentially violated data protection regulations such as GDPR and CCPA. The notification outlined the operational and legal risks Meridian now faced, specifying how Mark's unilateral deletion compromised client confidentiality, disrupted service continuity, and exposed the company to regulatory penalties. By involving the compliance department, we ensured an additional layer of corporate accountability beyond HR's purview. The filing of the wrongful termination claim and the compliance notification effectively escalated the matter from an internal personnel dispute to a formal legal and regulatory issue. Within days, Meridian was compelled to respond. The company's legal counsel reached out to Laura, indicating that Meridian was aware of the seriousness of the allegations and the potential financial and reputational exposure. This communication set the stage for negotiations, but also made clear that Meridian was preparing for possible litigation if a settlement couldn't be reached. At the same time, regulatory bodies initiated preliminary inquiries into Meridian's data handling practices. These inquiries focus primarily on the deletion incident, specifically whether Meridian had adequate safeguards and controls to prevent unauthorized access and data destruction. The investigation brought external scrutiny that amplified the pressure on Meridian's leadership to address the situation swiftly and transparently. Failure to do so risked substantial fines. Initial estimates suggested penalties could exceed $250,000, a figure that underscored the gravity of the compliance failures exposed. Compounding Meridian's challenges, several key clients affected by the deletion threatened contract terminations. They cited concerns over data integrity and service reliability, demanding assurances that their sensitive information was secure and that operational disruptions would be rectified promptly. These threats jeopardized millions in revenue, intensifying internal urgency. Meridian's account managers contacted me confidentially, seeking insights on mitigating client concerns, indicating that despite the conflict, my expertise remained indispensable. Meanwhile, Mark's behavior shifted noticeably as the fallout unfolded. His earlier confidence gave way to increasing desperation. I received several unsolicited calls and emails from him, where he attempted to negotiate informal arrangements, proposing consulting fees if I would assist in repairing the system issues his deletion caused. Recognizing these overtures as attempts to mitigate his personal exposure and circumvent formal proceedings, I declined politely but firmly. I communicated that all future interactions would be managed exclusively through Laura, emphasizing the need for professional boundaries and legal protocol. Internal colleagues expressed concern about the department's deteriorating environment. While cautious in their conversations, some reached out privately to offer support or share observations about the operational difficulties and Mark's erratic conduct. I maintained a neutral and professional demeanor in all interactions, neither confirming nor denying the full extent of the legal actions underway. This measured approach was deliberate, aimed at preserving my credibility and preventing any premature disclosures that could jeopardize negotiations or client confidence. Throughout this phase, I continued to document every development with precision. I logged all communications, including emails, phone calls, and meetings, ensuring accurate timestamps and detailed summaries. Every client complaint or internal system error was catalogued with corresponding technical reports from IT. This comprehensive record-keeping fortified our position, ensuring that any future disputes or negotiations would be supported by irrefutable evidence and an unbroken chain of documented events. Working closely with Laura, I refined our legal strategy in response to Meridian's shifting posture. We anticipated increased resistance from Meridian's management and Mark himself, preparing counter-arguments and reinforcing our evidentiary base to handle attempts at deflection or intimidation. Laura reinforced the importance of maintaining professionalism and patience, focusing on the long-term goal of securing fair recognition and compensation without resorting to public confrontation. The convergence of legal filings, regulatory inquiries, and client threats plunged Meridian into a state of crisis management. The company's leadership convened emergency meetings to address mounting risks, while legal and compliance teams scrambled to contain the damage. In this environment, my calm, documented, and strategic approach distinguished me as a responsible stakeholder rather than a disgruntled employee. The pressure on Meridian to resolve the situation on terms favorable to me increased steadily, setting the stage for forthcoming negotiations over my role and severance. At this juncture, the professional and legal stakes were high, but I remained resolute and composed. I understood that the interplay of contractual rights, regulatory compliance, and client relationships had created a complex matrix of leverage. Rather than capitulate to pressure or engage in direct confrontation, I maintained a posture of measured authority, allowing the documented facts and legal processes to unfold with maximum effect. The next phases would demand continued discipline and strategic engagement, but the foundation we had built was solid and compelling. As the investigations deepened and Meridian's internal review progressed, the consequences of Mark Benson's actions began to cascade through the company's operations and reputation, confirming the severity of the situation we had anticipated. Within days of filing the formal claims and initiating regulatory inquiries, Meridian's leadership took decisive disciplinary action. Mark was suspended pending a full, independent investigation into his conduct. This suspension was a clear acknowledgement of the gravity of his breaches, but it also marked the beginning of a broader corporate reckoning that would ripple through multiple facets of the business. The immediate aftermath of Mark's suspension was palpable in both internal communications and external perceptions. Meridian's stock price registered a sharp decline of approximately 4%, reflecting investor concern over the unfolding crisis and the potential financial liabilities the company faced. This drop was not merely a market reaction. It underscored the tangible impact of operational instability and governance failures on Meridian's valuation and credibility. Investor reports cited client defections and regulatory scrutiny as primary factors undermining confidence, placing additional pressure on Meridian's executive team to contain the fallout swiftly. Internally, a series of comprehensive audits were launched to assess the full extent of policy violations and operational vulnerabilities exposed by Mark's unilateral deletion of client files. These audits uncovered multiple additional infractions beyond the initial incident, ranging from lapses in data access controls to failures in adherence to documented IT protocols and escalation procedures. The findings revealed systemic weaknesses in Meridian's governance framework, highlighting how Mark's reckless decision had exploited gaps in oversight and controls that should have prevented such a breach. The audit reports detailed violations of internal security policies, inadequate supervisory checks, and failures in compliance training across affected departments. These revelations triggered a cascade of leadership adjustments. Several senior managers associated, directly or indirectly, with the oversight of the Client Relations Department were reassigned or placed under review as the company sought to demonstrate accountability and restore operational integrity. The HR department initiated leadership development programs aimed at tightening supervisory discipline and reinforcing compliance culture, signaling a significant pivot in Meridian's corporate governance approach. Meanwhile, industry forums and professional networks began circulating news of Meridian's data deletion scandal. The incident quickly became a cautionary example of what can happen when cost-cutting imperatives override prudent data governance and employee relations. Trade publications dissected the case, analyzing the company's vulnerabilities and management missteps. This negative publicity further eroded Meridian's standing in the marketplace, complicating client retention efforts and recruitment of new talent. The reputational damage underscored the long-term risks associated with Mark's impulsive act, extending beyond immediate financial losses to jeopardize Meridian's competitive positioning. On a personal level, the professional upheaval coincided with significant strain outside the workplace. The stress and time demands of managing the legal and operational crisis contributed to the dissolution of my marriage. I initiated divorce proceedings, ensuring all financial and asset divisions were handled equitably and transparently, drawing on detailed records of my financial contributions and professional earnings. This personal transition, while challenging, was managed with the same methodical attention to documentation and legal procedure that characterized my professional response. Financially, the mounting legal challenges imposed substantial costs on Meridian. Projected expenditures on legal fees, compliance remediation, and operational recovery escalated rapidly. Estimates exceeded $180,000 within weeks. These figures were communicated to the company's board and reflected in public financial disclosures. The scale of these expenses reinforced the significant material consequences of Mark's misconduct, highlighting the avoidable nature of the crisis and the urgency of implementing corrective measures. Moreover, Meridian initiated a formal review of Mark's professional credentials. The company's compliance and legal teams submitted findings to the appropriate licensing bodies, flagging the breaches of fiduciary duty and professional misconduct associated with his role as a department supervisor. This review placed Mark's professional license under threat, with potential suspension or revocation looming, depending on the investigation's outcome. The prospect of such disciplinary action underscored the seriousness with which regulatory authorities viewed his conduct and added a personal dimension to his professional downfall. Throughout this period of cascading consequences, I maintained a disciplined, strategic posture. My focus remained on ensuring that each development was meticulously recorded, analyzing how the expanding scope of the crisis strengthened my leverage in ongoing negotiations and potential litigation. The progression from isolated file deletion to systemic leadership failures, financial losses, and regulatory reviews illustrated how one calculated act of sabotage had unfolded into a comprehensive corporate crisis. This multifaceted collapse of Mark's professional standing and Meridian's operational stability served to validate the strategic patience and thorough documentation that Laura and I had emphasized from the outset. Instead of escalating prematurely, we allowed the documented facts and institutional processes to work in our favor, leveraging each new development as a stepping stone toward restoring my professional rights and securing equitable outcomes. Yet with Meridian's leadership in flux and the company grappling with reputational damage and financial strain, the situation remained professionally precarious. The next stages would require careful negotiation, balancing the company's interest in damage control with the need to recognize my contributions and protect my legal rights. The stakes were high, and the unfolding events underscored the complex interplay between individual actions and corporate accountability in today's regulatory environment. As the dust settled on this phase, I was keenly aware that the professional battlefield was far from resolved. The layers of legal, financial, and reputational challenges confronting Meridian and the personal and professional consequences for Mark would continue to influence the negotiations and strategic decisions ahead. My role was to navigate this complexity with continued discipline, ensuring that justice and professional recognition were secured without compromising my integrity or long-term career prospects. Legal proceedings unfolded over several months, marked by rigorous negotiations, detailed submissions of evidence, and formal hearings under the oversight of employment arbitration panels and regulatory authorities. Throughout this process, my legal team and I maintained a steady approach, presenting a comprehensive dossier that highlighted the multiple layers of Meridian's liability resulting from Mark Benson's actions and the company's inadequate response. The arbitration panel ultimately concluded that Meridian Solutions had engaged in wrongful termination practices by attempting to dismiss me without proper cause, predicated on the fabricated narrative stemming from the deletion of critical client files. The panel recognized that the company's failure to follow internal policies, compounded by Mark's deliberate sabotage, constituted violations of both employment law and fiduciary duty standards. As a consequence, Meridian was ordered to provide full severance compensation consistent with my contractual entitlements, as well as additional damages to address the material harm caused by the data loss. The financial settlement awarded to me totaled $150,000, comprising $120,000 in severance pay, reflecting my annual salary and contractual protections, and an additional $30,000 specifically allocated as compensation for the economic impact of the destroyed client data. These figures were carefully calculated based on documented revenue tied to the affected accounts and the projected costs associated with data restoration and client relationship rebuilding efforts. The settlement terms also included provisions for enhanced severance benefits contingent on non-compete compliance and confidentiality agreements, which I agreed to after thorough legal consultation. In parallel with the employment arbitration, regulatory agencies intensified their investigations into Meridian's data governance practices. The data deletion incident triggered a detailed audit by state and federal compliance bodies overseeing data privacy regulations, including GDPR and CCPA enforcement offices. Meridian faced fines totaling $275,000, reflecting both the negligence in protecting personally identifiable information and the failure to maintain appropriate data preservation and access controls. These regulatory penalties were accompanied by mandated corrective action plans requiring Meridian to overhaul its data management policies, implement stricter oversight mechanisms, and provide comprehensive employee training focused on data security and compliance. The regulatory findings explicitly cited the company's failure to enforce multi-level approval processes for data deletions and inadequate supervisory controls, underscoring systemic weaknesses that had allowed Mark's unauthorized actions to proceed unchecked. The combination of legal rulings and regulatory sanctions placed significant pressure on Meridian's leadership. The company's board of directors authorized these settlements and compliance measures as part of a broader effort to stabilize operations and mitigate further reputational damage. While Meridian did not publicly admit wrongdoing beyond regulatory acknowledgements, internal communications revealed a commitment to restructuring governance frameworks and enhancing risk management protocols. On the personnel front, the consequences for Mark Benson were severe. Following the arbitration outcome and the internal investigation, Meridian suspended him indefinitely pending further review. Additionally, the company reported the findings to relevant professional licensing boards, leading to disciplinary proceedings that resulted in Mark being barred from holding executive positions in the industry for a minimum of 3 years. He was also personally fined for breach of fiduciary duty and professional misconduct, marking a significant professional downfall consistent with the gravity of his actions. The employment arbitration and regulatory outcomes attracted attention within industry circles. Trade publications and professional associations analyzed the case extensively, highlighting it as a landmark example of the critical importance of data governance and employee protections in client relations management. Articles emphasized how the case underscored the risks companies face when cost-cutting measures override compliance and internal controls, offering cautionary lessons on preserving intellectual property and respecting contractual obligations. Professionally, the resolution significantly enhanced my standing in the marketplace. In addition to the financial settlement, the arbitration affirmed my ownership rights over the custom CRM modules I had developed and maintained. This intellectual property recognition not only bolstered my credentials, but also expanded my career opportunities beyond Meridian Solutions. I leveraged this outcome by licensing the proprietary software to other firms and integrating it into my consulting practice, thereby generating new revenue streams and professional visibility. Throughout the process, my strategic focus on meticulous documentation, calm negotiation, and leveraging contractual protections proved decisive. By systematically building a robust case and engaging expert counsel, I was able to transform a deliberate act of sabotage into a professional vindication. The legal and regulatory judgments reinforced the principles of fairness, accountability, and the value of thorough evidence in resolving complex workplace disputes. While the case had significant personal and professional costs, the outcomes validated the efficacy of a disciplined, evidence-driven approach. The combination of severance compensation, damage awards, regulatory fines against the company, and professional sanctions against Mark created a multifaceted accountability framework. This framework not only addressed immediate harms, but also contributed to broader industry awareness and improvements in data governance practices. As the legal phase concluded, I remained fully engaged in ongoing discussions with Meridian's leadership regarding transition arrangements and continuing collaborations, ensuring that the professional rapport established through these proceedings would support future endeavors. The case became a defining chapter in my career, demonstrating how strategic patience and professional rigor can navigate even the most challenging betrayals within corporate environments. After months of negotiation and legal maneuvering, I accepted a director role at a competing firm, a position offering a base salary of $95,000, about 20% higher than my previous compensation at Meridian, and crucially, full authority over data management. This role was designed with explicit contractual language, granting me control over client data systems, including the autonomy to implement secure backups and customized CRM modules without interference. My prior experience and intellectual property credentials, secured through the arbitration, positioned me uniquely to drive improvements and avoid the pitfalls I had witnessed. The transition was deliberate. I ensured that every element of the new contract was reviewed thoroughly, focusing not only on salary and bonus potential, but also on data ownership clauses, severance terms, and non-compete provisions aligned with my broader consulting ambitions. Before signing, I coordinated with my legal counsel to confirm that the intellectual property rights I had retained over the CRM modules were properly recognized and transferable for licensing and further development. This was critical. Not only did it protect my proprietary work, but it also created a foundation for building an independent consulting practice alongside my directorship. Since assuming this new role, my consulting practice has expanded considerably. Leveraging the CRM tools I had developed, I now offer tailored client management solutions to a range of mid-size firms seeking to enhance data security and operational efficiency. The proprietary nature of these tools, coupled with my documented track record of success, has attracted clients keen on preventing the kind of data loss and mismanagement that derailed my previous department. My ability to draw upon lived experience, both technical and legal, has become a valuable differentiator in the marketplace. This dual professional path, serving as a director with clear authority and maintaining an active consulting portfolio, has given me renewed confidence and control over my career trajectory. I have implemented rigorous documentation protocols in my current role, drawing directly on lessons learned from Meridian. These include multi-layered encrypted backups, detailed audit trails, and transparent communication channels with both internal teams and external clients. This approach not only safeguards data integrity, but also builds trust with stakeholders, preempting conflicts and regulatory risks. Reflecting on the entire ordeal, I recognize that it was the combination of methodical documentation, calm strategic thinking, and comprehensive legal awareness that turned a potentially career-ending betrayal into a structured opportunity for growth. From the moment Mark Benson deleted those files in front of 32 colleagues, I refrained from impulsive reaction. Instead, I focused on collecting evidence, understanding contractual protections, and engaging expert counsel to navigate the complex legal landscape. This patient, step-by-step approach ensured that every move reinforced my professional position and opened pathways for advancement. There was no room for emotional outburst or rash decisions. Maintaining professional composure allowed me to control the narrative and command respect from all parties involved, from Meridian's HR and legal teams to regulatory bodies and future employers. The strategic leverage gained through documented evidence and legal expertise underscored my value as an indispensable asset rather than a liability. It also underscored the importance of contractual clarity and data governance protocols in protecting employee rights and company assets alike. Looking ahead, I intend to continue leveraging both my leadership role and consulting practice to influence industry standards around client data security and management. The proprietary CRM modules I developed are set for further refinement, with plans to integrate emerging technologies that enhance real-time analytics and automated compliance monitoring. These innovations are guided by the professional lessons embedded in my past challenges, specifically the critical need for resilience, transparency, and accountability. Ultimately, this experience has reaffirmed my belief in the power of strategic patience and professionalism as tools for navigating even the most fraught workplace conflicts. The betrayal I faced at Meridian was profound, but by adhering to a disciplined, evidence-driven response, I was able to transform a crisis into a platform for renewed professional strength and industry impact. Today, I lead with a clearer vision, fortified by the knowledge that meticulous preparation and legal insight are indispensable in safeguarding both career and reputation.